Good, good morning. Mr. Maxwell, can you hear me? I see you on the screen.
Your Honor, yes, I can hear you.
Thank you very much for confirming. My name is Felicia Orth, hearing officer appointed by the Water Quality Control Commission to conduct a hearing in WQCC 23-84. This is a water reuse rule. We are on the fourth day of hearing. It's 9 a.m. So this is the seventh opportunity for public comment, non-technical public comment. There'll be another opportunity at 1 o'clock this afternoon, a ninth opportunity at 9 tomorrow morning, and a 10th opportunity at 1 o'clock tomorrow afternoon. There are just a few guidelines. I have to ask you to stay within 3 minutes, and I will be timing the comment. I have to ask you to collect your thoughts because I can only call on you once. And to the extent you have more to say than can fit inside 3 minutes, please write up whatever you'd like and send it to Pam Jones. You'll find her information the same place you found the information to join us this morning. It can be of any length and will be given the same weight. So I have 7 folks this morning who have reached out to Pam to offer their name. If you're on the platform and have not yet indicated to Pam that you'd like to offer comment, please do that through the chat and we'll get started. Carla Sontag. Carla Sontag.
Good morning, members of the committee. I'm Carla Sontag, President and CEO of the New Mexico Business Coalition.
Okay, hold on 1 second. Do you swear or affirm to tell the truth?
I do.
And if you would spell your first and last name for the transcript.
Yes, Carla, C-A-R-L-A, Sontag, S-O-N-N-T, like Tom, A-G.
All right, thank you. I'll start your time.
Thank you. Water is one of the most important conversations we can have in New Mexico. It is a precious and very limited resource. That is why we must do everything we can to conserve and reuse it however possible. If we don't take steps now to reuse water, we will be leaving future generations in a precarious situation. In working with New Mexico businesses over the past 15 years, water has sometimes been an issue. Sadly, we have lost opportunities for companies to locate in New Mexico because of insufficient water or because of strict rules on its usage. That means our state has lost opportunities for economic diversification and job creation. It would be especially troubling to lose a new company seeking to reuse water in its own operation. If we don't provide the opportunities in New Mexico, companies will and have gone to states that either have more water or better usage rules. We trust that in this rulemaking process, you can develop fair and equitable rules that will ensure the safe reuse of water. If we do this wisely, we can conserve for future generations while allowing our businesses to thrive and create jobs. This is also a great opportunity to create new jobs as we look to a workforce of skilled operators monitoring water usage and everything that goes with that. I encourage you to look for the good of our entire state and all of our people in finding ways to successfully reuse water that would otherwise be wasted. Our limited resources really mandate the wise reuse of water. Thank you for the work you're undertaking and for consideration of my comments.
Thank you, Ms. Sontag. Dan Pritchard. Is Dan Pritchard online?
Yes,
Oh, hello. Mr. Pritchard, do you swear or affirm to tell the truth?
I do.
If you would spell your first and last name for the transcript, please.
First name is spelled D-A-N-I-E-L. Last name Pritchard, P-R-I-T-C-H-A-R-D.
Thank you. I'll start your time.
Good morning, Commissioners, Chairman. My name is Daniel Pritchard, and I live in Taos, and I am on the executive board of Renewable Taos, an all-volunteer organization working to promote renewable energy while also protecting the environment and making our community more sustainable. I'm also a state licensed water system operator, and that gives me firsthand knowledge, experience, and responsibility in providing clean, safe drinking water to the 75 residents in my subdivision. My comments today are about responsibility. The New Mexico Environment Department is who we depend upon to protect the waters of our state and set appropriate rules. I support all efforts to prohibit discharge of any produced water outside of the oil field. I was taught that if I made a mess of something, I was responsible to clean it up. The oil and gas industry is accountable and responsible for cleaning up their mess, including spills and discharges of produced water. I urge the Water Quality Control Commission to adopt stringent rules that prohibit discharges of produced water outside of the oil fields and ensure that produced water is safely transported, stored, and disposed of. This can be expensive, but as we all know, the oil and gas industry is making record profits so they can afford it and clean up their own mess. Thank you for your time.
Thank you very much, Mr. Pritchard. Julia Bernal? Julia Bernal? No. All right, if Ms. Bernal rejoins us, I will take her comment. Michael Swearingen?
Yes, thank you.
Oh, hello. Do you swear or affirm to tell the truth?
Yes,
And would you spell your first and last name for the transcript?
Michael, Michael, Swearingen, Sweringen.
Thank you. I'll start your time.
Good morning, Commission members. Thank you for this opportunity to speak. I'm Michael Swearingen. I live in Northwest Albuquerque. I'm a science teacher teaching biology, earth science, and the science of global overheating. Half of all the oil and 2/3 of all the natural gas produced in the United States is produced through fracking. But this also leaves behind millions of gallons of water filled with toxic waste products for each well. How do oil and gas companies get rid of this toxic fracking wastewater, which they call produced water? Our governor has proposed a strategic water supply plan that puts forward one new possibility. Let's try to clean this toxic wastewater and then reuse it. But here's the problem. They don't really know how to clean up this toxic fracking wastewater because they're not exactly sure what's in it. The fracking fluids used to fracture the underground rock are privately owned. They're trade secrets. The oil and gas companies won't share this information. And toxic fracking wastewater can have thousands of different chemicals in it, including forever chemicals, PFAS, benzene, heavy metals like arsenic and lead, and radioactive chemicals. These can cause cancer, birth defects, and early death. Here's what I thought about when I heard about this problem. I'm holding up a bottle of pills. Imagine I have a bottle of red, green, and blue pills, and I tell you, take these. They're safe. Trust me. Of course, you would never take them until you knew exactly what was in them. The oil and gas industry and our governor are doing the exact same thing. They're telling us that we can clean and reuse toxic fracking wastewater, but how do you clean something when you don't even know what's in it? Here are 3 things we should do. Make sure pilot projects, demonstration projects, and industrial projects to clean and reuse fracked water continue to take place in gas and oil fields only, period. Remove this line from the proposed rule, quote unquote, authorization for reuse of produced water in industrial projects, end quote. because there's no evidence that toxic fracking wastewater, which they call produced water, can be reused safely. There are no science-based safety standards for this. And finally, the big picture, we need to begin the responsible phase out of oil and gas production and to replace oil and gas energy with energy from solar, wind, and energy savings action. Thank you very much.
Thank you, Mr. Swearingen. Stacy Slay. Stacy Slay. If she rejoins us, I'll take her comment. Enedith Lopez. Okay. Can you?
Hi, sorry, I'm here.
Oh, terrific. Do you swear or affirm to? Excuse me. Do you swear or affirm to tell the truth?
Yes,
And would you spell your first and last name for the transcript?
yes. My first name's Enedith. My last name is Lopez, Lopez.
Thank you. I'll start your time.
Before I actually start my time, can I just address something? I definitely want to address the harm that's caused by the lack of interpretation and language access in this hearing. Members of the community took their day on Monday to attend the hearing to have their voice heard, and they frankly waited until 5 p.m. after the public hearing was limited to 45 minutes, and frankly weren't assisted or allowed to give their comments, which is completely inappropriate. It shouldn't take community members to request giving comments in Spanish. It should be the responsibility of the department to ensure that that is available and accessible. I mean, the state of New Mexico has a large immigrant population, and immigrant justice advocates consistently have to find ways to find language access to ensure that things are being communicated properly. So I really do want to just make it a point that it is the responsibility of NMED to ensure that that is something that's made accessible, regardless if, there's that public notice for 15 days. People who have to work and feed their families and have to go to work don't have the time to make that request. And frankly, that's on the department. But I'm ready now to give my comment if I'm allowed to.
Let me ask just one thing. First, thank you for your comment about simultaneous interpretation. I do understand that there were some folks on the platform on Monday who were frustrated that there was not simultaneous interpretation. I am hoping that the folks who experienced that were informed or came to be informed that we will accept public comment in writing in Spanish and have that translated for the commission prior to their deliberations, well ahead of their deliberations, so that it would come into the record as public comment, be given the same weight. And I hope that folks were informed of that.
Okay, I appreciate that response. But folks were informed of that, and even talking with the administrator, they said that they would be allowed to voice their comment, and that's really where I'm taking an issue with, is that people were not allowed to speak. So the general public, there are folks in the general public who do understand Spanish. I understand the record and the need for the commission to understand it, but community members should still be allowed to speak regardless of whether or not there is that interpretation. But would I be allowed to give my comment now?
Yes. Go ahead. I'll start your time now.
Thank you. Thank you, Chair, members of the Commission, and hearing officer. My name is Enedith Lopez, and I'm the Policy Campaign Manager at Youth United for Climate Crisis Action, also known as YUCCA. Our organization is led by young, Indigenous, and people of color with thousands of supporters across the state. We are deeply committed to fighting for environmental justice, as we see it as our responsibility to honor the longstanding tradition to safeguard our lands and waters, which has been passed down to us by our communities and our ancestors. We have a duty to protect our water, which is sacred, precious, and irreplaceable. We agree that industry must be prohibited from discharging produced water into our ground and surface water, but it is crazy to us that this is something that needs to be established. How dare the industry create this toxic radioactive waste and then threaten to directly poison our waterways with it? But keeping them from dumping it on our crops and plants or dumping it into our waterways is not enough. We must hold them accountable for the toxic radioactive waste they have created. The rule before you totally fails to hold them accountable for their toxic waste. In fact, the rule before you allows industry to take their toxic radioactive waste and experiment with it at the expense of worker safety, at the expense of public health, and at the expense of our environment in their pursuit of profit. How so? Doesn't this rule include requirements for closed loop projects and zero discharge to ground and surface water? It does, but that's not the whole story. This rule includes no scientifically based standards to ensure that workers are protected throughout the treatment, handling, and disposal process. This rule includes no standards for treatment. This rule includes no standards for waste disposal from projects, except the standards already in place under the Oil Conservation Commission, which are already not being enforced, as release of fracking waste takes place daily throughout our state. We have heard affirmed in the testimony by NMED that produced water is toxic and that its toxicity is highly variant and not fully known due to the refusal of the industry to disclose their toxic chemical concoctions. We have heard affirmed that this rule is not setting forth requirements or recite or enforcement through a permitting process for the reuse of produced water for industrial projects. Instead, industry just gets to share their descriptions of their projects and their plans. And if they do so, as long as there's no discharge to ground or surface water, they can proceed. There are no safety protections. There are no environmental protections. Spills and accidents are anticipated in this rule, but there are no minimum standards for financial assurances. A company can take their toxic fracking waste and use it to grow agricultural products in a greenhouse. They could do whatever they want to treat the water. They would just need to describe their plans and the notice of intent. And they could minimize the risk of spills and worker exposure in whatever way they want, so as long as they describe their plans in the notice of intent. The same is true when this rule is used to try and make hydrogen with fracking wastewater. All the companies have to do is describe their plans. This commission is charged with the duty to protect our water, public health, and interests, and the environment. This commission must put safeguards in place based on scientific evidence, because no evidence exists to support the claim that reused produced water is safe, and the Environment Department has failed to include adequate standards. The rule should be rejected, and an alternative rule should be adopted that prohibits all reuse off the oil fields to ensure the safety and well-being of our communities and the protection of our sacred and precious water. Thank you.
Ms. Lopez,
Yes.
one more thing before I move to the next person. There's a significant possibility that we will not finish the hearing this week, and we'll have to resume at a later date, which would not be next week. I'm not sure when it would be. And with enough notice, obviously, a team of interpreters could be contacted, and I could invite oral comment in Spanish as part of that resumption. Would you please reach out with contact information to Pam Jones so that we can contact you and see if that would be a helpful thing to do when we resume? Okay, I've lost her. Okay, the next person is Ruth Striegel or Striegel.
Yes, that's me.
Oh, hello. Do you swear or affirm to tell the truth?
I do.
And if you would spell your first and last name for the transcript.
Yes, my first name is Ruth, Ruth. My last name is Striegel, Striegel.
Thank you. I'll start your time now.
Thank you for the opportunity to speak. My name is Ruth Striegel. I live in Albuquerque, and I serve as the co-chair of the Board of Directors of New Mexico Interfaith Power and Light. I urge the Commission to make sure the rule is crafted in a way that keeps any form of produced water out of our groundwater, surface water, soil, or anywhere that might allow it to contaminate our water or living organisms. Do not allow treated produced water to be used in agriculture. The proposed language is clear on this point and should be retained. To make it very clear what the limits on use are, remove the definitions of use for agriculture, food crop applications, environmental buffers, etc. This section of the proposed rule is inconsistent with the prohibition on discharge and weakens the rule. Our current technology isn't able to lower all the toxins in produced water to safe levels. The use of any form of produced water must be limited to projects within the oil field. Remove the language that allows for its use in industrial projects. We must do all we can to safeguard our precious water, which sustains all life in New Mexico. Releasing treated produced water into our environment would have tragic consequences and must not occur. Our human lives are supported by the complex web of life around us, and if we are to continue existing, we must stop exploiting the earth for profit and live with the realization that we have to respect and live in balance with our environment. Please remove language in the rule on use for agricultural and industrial projects and retain language prohibiting discharge to surface or groundwater. Thank you for your work on behalf of all of us.
Thank you, Ms. Striegel. I don't see anyone in the room I don't recognize, but let me just ask if there's anyone in the room who came to offer public comment this morning.
Good morning, I did.
No. I'm sorry, who spoke?
Good morning, this is Beata Sosi. I had emailed you, but I don't know if it was received.
I'm happy to accept your comment, Ms. Sosi. Do you swear or affirm to tell the truth?
Yes.
And if you would spell your first and last name for the transcript.
Beata, Beata, Sosi, Tsosie.
Thank you. I'll start your 3 minutes now.
Good morning, commissioners and hearing officer. Thank you for this opportunity. I'm the organizational director of Breath of My Heart Birthplace, birth center in traditional Hapo-Inga territory. And on behalf of Breath of My Heart Birthplace and our stakeholders, we are very concerned about the rule changes proposing to allow toxic fracking wastewater for uses outside of oil fields. We are concerned about the extremely harmful impacts on our pregnant population, land, water, and communities who rely on New Mexico's waterways and sole source drinking water aquifer. There are devastating health and ecological impacts from fracking waste on our individual and collective reproductive health and rights. Water quality and any attempt at remediating violated waters must center Indigenous pregnant peoples as the standard for environmental protections. Midwives conceived of our communities are keepers of our ways of knowing, from matuing all our relations to birth within Atgin, respect, sigi, love, Herasek ane, and embrace of Nanuchukwejo, our earth grandmother, E Opamanu, in the order of the universe. Our Ha, our breath of life, our living prayer, is that our children are born rooted in safety, including environmental safety, within our spiritual, cultural, and land-based existence. For too long, Native and land-based families in New Mexico have been dealing with discriminatory policies that have historically been felt by generations as acts of violence on our shared lands, and ultimately enabled and perpetuated a culture of violence on our bodies. In order to continue to lay claim to our ancestral places, the suppression of our matrilineal ways of knowing are being replaced with a contaminated existence. This ongoing contamination is of great concern for the future well-being of our children and birthing people in our communities, and is rooted in an ideology that is not indigenous to these lands and does not love or care for us. As midwives and birth workers, we care for and honor our teachings in living in right relations within our cosmology, environment, and in working to maintain balance. Our ancestral lands and waters are a source of strength, active spirituality, and an archive of living memory for how to exist as a part of our ecologies unique to our region. Since time immemorial, we have given birth, prayed, and died in these precious landscapes. Indigenous birthing people must be centered in protections, and we oppose any use of produced fracking waste. We must transition from any economies dependent on the continued destruction of the elements that ensure our collective survival and continuance of our children. Thank you for prohibiting the discharge of reused produced water to surface or groundwater resources. Thank you for the removal of any definitions for uses such as agriculture that are not consistent with this prohibition. Thank you.
Thank you very much, Ms. Sosi. Is there anyone else on the platform who would like to offer public comment at this time? There will be 3 more opportunities. 1 o'clock this afternoon, 9 tomorrow morning, and 1 tomorrow afternoon.
I would like to comment.
And who is this?
India Omega.
All right. Do you swear or affirm to tell the truth?
Yes, I do.
And if you would spell your first and last name for the transcript, please.
It's EYNDIAOMEGA.
Thank you. I'll start your time now.
Good morning. I am a midwife and I serve at Breath of My Heart. I serve prenatal families and take care of them throughout their prenatal care and newborn care as well as postpartum. And I oppose this rule. There is no scientific evidence that this is a safe practice. The risk of birth defects for families, I believe, is inevitable, and no person should be disposing of water off of the oil field. And I'm here just to speak on behalf of families so that their water is protected and Indigenous water is protected.
Thank you very much, Ms. Omega. Anyone else on the platform who would like to offer public comment at this time? The next opportunity is 1 p.m. No? Okay, we will return then to the technical case. And when we interrupted the technical case originally, we were in the middle of the cross-examination of the department. So, no, Mr. Hightower's in San Francisco. He's going to be on Zoom later. So let's go back to the cross-examination of the department. If you would array yourself there at the desk.
Madam Hearing
We had, Mr. Wexler.
I apologize. As they're sort of getting ready, when it's convenient for you, can we discuss scheduling issues? I'm just concerned about some of my witnesses and who have to travel, and so I'm trying to understand when I should have them be here. So whenever it's convenient, I'd appreciate it.
All right, thank you, Mr. Wexler. So NMOGA had completed its cross-examination. Mr. Maxwell had given it a good start, but I don't believe he was finished with his cross-examination. So we will return to Mr. Maxwell. Yes, please, we're going to cover the names first. Go ahead.
Susan Antonia Lucas Kamat, SUSAN space AATONIA. Sorry. What? I'm not done with my last name. 2-word last name, LUCAS space KAMAT.
My name is Jason Herman, JASON HERMAN.
There I go again, early in the morning. My name is Jennifer Fulham, JENNIFER. F is in Frank, U is an umbrella, LL, A is in Adam, M is in Mary. My name is Kathleen Murphy, Kathleen Murphy. You know that.
My name is Leihu, Leihu.
And Teresa Andrew Knight is the lawyer representing them. And our first cross-examiner is on the platform, Mr. Maxwell.
Thank you, Your Honor. Good morning. Today, I'll continue my cross-examination of Miss Fulham. Tuesday afternoon, I asked you about the hearing notice you were responsible for posting in this matter. Is that correct?
Yes.
As we left off, I had asked why you chose to apply the State Rules Act's definition of an agency's website to meet the notice requirements for this hearing notice instead of using the definition of Commission's website found in 20.1.6 INMAC, correct?
I believe I recall that question.
At that time, you testified that the department does not have access to the Commission's website. Do you remember that?
Yes.
To clarify, is it specifically your division within the department that does not have access to the Commission's website?
Can you repeat that? I just want to make sure I'm answering clearly.
To clarify, is it specifically your division within the department that does not have access to the Commission's website?
I believe there are other divisions that may not have access to the Commission's website. I'm not sure who has access to edit it.
Does the Water Protection Division have access to the Commission's website?
No.
Isn't the Office of Public Facilitation an office within the Environment Department?
To my knowledge, yes.
Isn't it true that the department's personnel at the Office of Public Facilitation have editorial access to the Commission's website?
I don't believe that's within my knowledge or excuse me, or my testimony.
We'll continue. Now, Ms. Fulham, you testified that posting the hearing notice on the Commission's website is a requirement of 20.1.6 INMAC, and that amendments considered by the Commission must comply with the procedural requirements of 20.1.6 INMAC. Is that correct?
Objection. That calls for a legal conclusion.
Mr. Maxwell, we have to walk this line of not asking technical witnesses for interpretations of the law. So
I
you
believe
can
that.
certainly.
I asked if she testified of that. I think it's a yes
Oh.
or no question.
Okay, so you're right. If it was in her testimony, you can certainly explore it. Do you remember if it was in your testimony, Ms. Fulham?
If he could give me a citation, that would be helpful.
Yeah, we would need
Where?
we would need a citation for that statement. I believe it misstates the witness's testimony.
Okay, Mr. Maxwell, can you point us to where she said that?
Okay. One moment. In your direct testimony at page 19, line 7, it starts, amendments must comply with the Water Quality Act, NMSA 1978, section 74-6-6, and 20.1.6 INMAC, which set forth procedural requirements for rulemaking proceedings before the Commission.
Yes, that was in my testimony.
To clarify, under the notice posting requirements of 20.1.6 INMAC, must the hearing notice be posted on the Commission's website and available for public review when it is initially posted?
I believe the language in 20.1 6, which was entered as an exhibit, has a definition for, actually, I don't know that we provided the definition for provide to the public in our exhibits, but it's my recollection that it does discuss posting the notice on the commission's website.
Ms. Fulham, could you please bring up New Mexico Environment Department's exhibit number 72?
Yes, give me a moment. I have it up.
Is exhibit number 72 a hearing notice for these rulemaking proceedings?
Yes, it's the notice that was published in the New Mexico Register on March 12th, 2024.
Was that 62 days before the hearing?
I believe so.
If this hearing notice, I'm sorry, I'll begin again. Is this hearing notice substantially identical to the one posted on the department's water reuse website page?
I believe it is near identical.
Can you differences between these two notices?
You broke up, Mr. Maxwell.
My question is, can you provide the differences between these two notices?
Thank you.
This notice is directly from the state register, and so the title, the date, would be different because it's specific to the register.
Is the content identical?
Yes.
I wish to direct your attention to the last sentence of the first paragraph of the notice. I will read it aloud and then ask you to confirm if I read it correctly. Are you ready?
Yes.
Please listen carefully. It reads, quote, please visit WQCC website prior to the hearing for at https://www.env.nm.gov/water-quality-control-commission/, end quote. Did I read that sentence correctly?
Yes.
Does this sentence indicate that the link I just read is the WQCC website?
Yes.
Does the first line of this paragraph use the acronym WQCC to mean the Water Quality Control Commission?
Yes.
Is it accurate to say that the second paragraph of this hearing notice indicates that the proposed regulations can be reviewed online at the WQCC website?
I don't believe so. Oh, let me read further along. The proposed regulations may be reviewed online at the, I'll abbreviate, the Water Quality Control Commission's website.
Is it accurate to say yes or no to that question?
Yes.
Do both the Schools Act and 20.1.6 NMAC require hearing notices to include an internet link providing the public with free access to the full text of the proposed regulations?
Yes.
In your expert opinion, would the full text of the proposed regulations need to be prominently posted at the internet link providing free access in order to meet the procedural requirement of a rulemaking hearing?
The regulations were posted on the Water Quality Control Commission's website under the Water Quality Control Commission's banner under 23-84R. And that was the version that was filed with the commission, and that is what was in the hearing notice. So, yes.
To clarify, is that on the WQCC link page or a different page known as the Docketed Matters website?
I believe it's under the WQCC's Docketed Matters website, if I recall correctly.
Are you aware if other boards and commissions also have their matters posted on the Matters website?
Yes.
Were the proposed regulations in this matter ever posted on the WQCC website for public review?
I don't know that they have a website for public review specifically.
Ms. Fulham, can you confirm if the department's water reuse website is located at a different website link than the WQCC website?
It is.
Before we finish with this exhibit, take a moment if you need. Can you confirm if this hearing notice contains any link to the department's water reuse website page?
I don't believe it does.
Ms. Fulham, you've mentioned twice during this hearing, once during your direct examination and once during member Brandcard's questioning, that the notice was posted on the WQCC website on March 26, 2024, 48 days prior to this hearing. Is that correct?
Yes.
Was March 26, 2024 a Tuesday?
I would have to look that up. Did you need me to?
Do you have your phone and can confirm that on your calendar?
I do not.
Objection.
Mr. Maxwell, if you want to make a representation as to what day of the week it was, you can ask her to assume it.
The day of the week was a Tuesday on March 26, 2024. Do you believe that?
I can assume that you have better access to that than I do at this moment.
It is. During your direct, did you testify that this hearing notice was posted on the WQCC website after the department received comments raising the issue of its absence on that page?
Yes.
Are you also aware that in my written comments, I raised the issue of the absence of the full text of the proposed regulations on the WQCC website?
Can you repeat that again? I think there was some interference.
Absolutely. Are you also aware that in my written comments, I raised the issue of the absence of the full text of the proposed regulations on the website, the WQCC website?
I remember that.
You've testified that the hearing notice was posted on the WQCC website on March 26, 2024. Would it also be correct to say that prior to March 26, 2024, there had been no hearing notice on the WQCC website for this rulemaking?
That would be a fair statement.
Were you aware that I sent an email to the department on Sunday, March 24th, specifically addressing the issue of the hearing notice not being posted on the WQCC website?
I was not provided that notice directly, but I believe it was sent to the department on Sunday around midnight or something, and then another one maybe on Monday.
Did you first become aware of the issue on Monday, March 25th, or Tuesday, March 26th, 2024?
I can't recall.
Is it accurate to say that the Water Protection Division managed to have the hearing notice posted on the WQCC website within 2 business days of my email being to the department?
We notified the Office of Public Facilitation to let them know of the shortcoming.
I'd like to know more about how that was accomplished. Was the division's request to post the hearing notice on the WQCC website delivered to the personnel at the Office of Public Facilitation via email?
I actually was not a part of that.
Were any of the members of this panel a part of that?
No,
On what day was this request delivered to the Office of Public Facilitation?
again,
Are
I
you
can't
aware?
answer that because I'm not aware.
Is it also true that the hearing notice was emailed to identified stakeholders on March 11th, 2024, which is 63 days for the hearing?
I believe that's in my direct testimony.
It is. Was this email sent to identified stakeholders in order to meet one of the requirements in 20.1.6 NMAC for providing the hearing notice to the public by the 60-day deadline?
I actually believe that we send it to the stakeholders in accordance with the State Rules Act, but it does also coincide with the requirements in the rule of
Are you aware?
20.1.6. I'm sorry.
Are you aware if this notice for this matter was ever emailed to personnel at the Office of Public Facilitation prior to the 60-day deadline?
Can you ask that question again?
Are you aware if this notice for this matter was ever emailed to personnel at the Office of Public Facilitation prior to the 60-day deadline?
I don't think I have that in my testimony, and so I don't know.
Can anybody on this panel testify to that?
No,
You testified that you believe the department did the best job in providing the hearing notice to the public. In light of these timelines we've explored, do you maintain that belief?
yes,
Despite the notice not being posted on the WQCC website by the 60-day deadline, are you testifying that the requirements of 20.1.6 NMAC have still been met because the Water Protection Division of the department lacks access to the WQCC page and has done the best job under these circumstances?
can you break that up into a couple of questions? I
Okay,
apologize. It was lengthy.
despite the notice not being posted on the WQCC website by the 60-day deadline, I'm asking if you're testifying if the requirements of 20.16 NMAC have still been met because of two reasons. One, the Water Protection Division of the department lacks access to the WQCC page, and two, has done the best job under these circumstances.
I'm going to caveat the answer to this question because it's an opinion whether we did our best job and whether that meets the requirements of 20.1.6 NMAC. So, do I believe that it was posted on the Office of or on the Water Quality Control Commission's webpage 60 days prior in accordance to 20.1.6 NMAC? No, that statement has been made. Do I believe that the department did their due diligence to put the notice out in all the required places as provided in my direct testimony to our ability and as I testified in my oral testimony? Yes.
Are you aware of the Water Quality Control Commission making any formal designations of its website?
I'm uncertain designations for what?
I'll read the question again. Are you aware of the Water Quality Control Commission recently making any formal designations of its official website?
Again, I'm uncertain designations doesn't have a designation of what to who.
Ms. Fulham, you wrote in your testimony that the commission granted this public hearing during their meeting on January 9th, 2024. Is that correct?
Yes.
Did you know that during the same meeting, the Commission adopted a resolution that designated the WQCC website as their, quote, own website, end quote?
I was not aware of that matter. It was outside the scope of my work.
Your Honor, I would now like to introduce an exhibit for identification that I believe will help clarify this matter. This is Maxwell's cross-exam exhibit number 1, the 2024 Open Meetings Act resolution of the Commission, adopted on January 9th, 2020. Ms. Fulham, do you have this in front of you?
No.
I believe you uploaded it into the Dropbox, Mr. Maxwell?
This is correct.
Okay, I'm sorry, you occasionally break up, which is why we have to ask you to repeat things occasionally. Ms. Pam, are you able to pull that up?
I can see the document on the screen. I'll just
Thank you.
lean back a little bit.
Thank you.
Ms. Fulham, have you seen this document before?
I'm familiar that there is one. I have not seen this personally.
I would ask you, but you do not have the copy in front of you. Your Honor, if there's no objection, I request that the Commission take administrative notice of the authenticity of this 2-page resolution signed by Chair Thompson, as it was officially adopted during the open meeting of the Commission on January 9th, 2024.
Yes, that is something the commission can take administrative notice of.
Thank you,
Let me
Your Honor.
pause. Hold on one second. Let me just pause in the event anyone wants to register an objection. All right, it's in the record.
Near the middle, there is a section boldly labeled Public Notices. Do you see that section?
I can.
Okay, I'm highlighting this area here. In Section A, following the phrase that notices must be, quote, posted prominently on our website, end quote, can you confirm that the link which follows is the same as the one provided in the hearing notice for this matter?
It appears to be.
In the context of this resolution, would you agree that the phrase our website refers to the Water Quality Control Commission's website?
Yes.
Would you then agree that by approving this resolution, the Commission officially recognized the WQCC website as their own website?
Yes.
Your Honor, based on Ms. Fulham's testimony about the Commission's acknowledgement of their official website, I request that Maxwell's cross-exam exhibit number 1, the 2020 Open Meetings Act resolution, be entered into evidence. This resolution, adopted when this public hearing was granted, clearly designates the WQCC website as the Commission's own website. It is crucial to confirm this website as the Commission's official platform for notices, as their procedures mandate posting hearing notices here at least 60 days in advance to validate the rulemaking process.
Yes, I admitted it a few minutes ago. So yes, it is in the record. It's admitted. It can have the designation you gave it.
Your Honor, that concludes my cross-examination of the department's witnesses.
All right, thank you, Mr. Maxwell. We can move then to Ms. Taylor on behalf of Select Water Solutions. Well, we've been going a little less than an hour. You want to get a start? All right.
Good morning.
Good morning. I'm glad to get back to the technical case with you guys. I know you're glad too, maybe. So let's start with notices of intent, the change in the May 6th rule that required two new provisions. And so the new provision in 20.6.8.400C2 requires persons implementing demonstration projects or industrial projects. Yes, ma'am. Section 20.6.8.400C2 of the proposed rule requires persons implementing demonstration projects or industrial projects to submit all research results to the department, correct?
Correct.
I believe that Mr. Herman said that that would mean that research results at the end of the process. Is that correct?
Yes,
So are you going to require intermediate results or not? Sounds like not. Is that correct?
that was not the intention of that portion of the regulation.
How would a person applying know that you want just results at the end of the process if the rule doesn't say that?
I would likely rely upon the word results as implicating the end of a project.
Okay, thank you. And I believe that Ms. Murphy testified that the purpose of the rule for notice of intent is to ensure no discharge. Is that correct? Correct. So I just have a question about that. How does knowing the amount of constituents, how does knowing the amount of constituents contribute to the purpose to determine that there will be no discharge?
I don't know that it necessarily does, but it contributes to knowing the final results. You analyze according to the consortium's sampling, and then you test it through the treatment train, and then you analyze the treated produced water, and you test the efficacy of the treatment.
And I would just add that the primary purpose is to ensure no discharge. We do have secondary purposes as well as tertiary purposes associated with our drafting of the rule.
I think this has been discussed before, but the department has not included any regulations or rules about protecting confidential information, proprietary information, or trade secrets, correct?
We have not included any regulations. The Water Quality Act does give us the authority to do that without regulations or promulgate regulations for consideration.
So let me make sure I understand here. So are you saying that you have the ability to protect trade secrets? And I'm just going to use that term generally. You have the ability to protect trade secrets without regulations?
I'm going to ask her to pull up the Water Quality Act so I can read you the exact citation.
Okay.
So that I don't parse it.
Are you looking for the confidential information section? 74-6-15?
I'm sorry, 74-6-1 to 5.
15, I believe.
I don't know that there's a 15. 74-6 dash
15. May I approach?
Thank you. Would you like me to answer a question, or would you like me to read that section out loud?
Well, let's just talk about the section generally.
Sure.
As I read it, and tell me if you read it differently, it says that generally speaking, information submitted under the Water Quality Act shall be public, but it does have an exception for trade secrets and similar items if a person can demonstrate to the commission or the constituent agency that the records, et cetera, would divulge confidential business records or methods or processes entitled to protection as trade secrets. Is that correct?
It is also followed by some exceptions, and I will note that the department has accepted confidential business information as well as national secrets, and we hold a very high bar. And we also, we hold a very high bar for that determination.
Do you mean that people have to go a long way to prove that it's confidential or should be treated confidentially?
No, I think what I'm saying is that that it takes a considerable amount of evidence for us to be convinced that it's confidential business information that needs to be protected.
I think that's what I asked. I think I asked,
Okay.
does it take a lot for someone to prove to you that it should be confidential, correct?
Yes.
Okay. This statute, as I read it, says that the commission, meaning the Water Quality Control Commission, shall promulgate regulations to implement the provisions of this section, including regulations specifying business records entitled to protection as confidential. That's in section B. Sorry, I should have said that to begin with. So do you agree that that's what the statute says?
Yes.
So has the commission promulgated such regulations?
I can only speak to the ground and surface water protection regulations, which do not include any provisions for confidential business information.
But you're telling me that you have kept them confidential in the past.
As a department.
Okay, what's your authority to do that then?
I believe there is, and I'm not expert, and it is also not in my testimony. The Air Quality Bureau has regulations that specifically state confidential business information. And they have regulations promulgated through the EIB.
So I think we've heard testimony or suggestions anyway that the lack of protection for confidential information is a damper on industry participating and, fully disclosing their information because of the trade secret issue. How could you help industry understand that they can be protected when there's no regulation? You say there's a very high bar. It seems, I don't know what the standards are. So how can we ensure confidentiality of trade secrets so that you can get the data you want?
Could you rephrase the question? I'm not sure I understand you completely.
Sure. I can remember my question. I think basically I'm asking, as far as we can see, part of the regulated community, there are no regulations about confidentiality. And that was a concern, especially with the notice of intent issue where people are asked to give all their results. So how can you help industry know that they can get how can you let industry know they can get protection for confidential information if they want to participate in demonstration projects?
I don't know that I have a good answer for you. I don't know that I even have an answer for you.
Would the department be willing to draft such regulations in cooperation with industry?
That's a pretty big ask, but I think Jen would like to respond to that.
If I may, given I generally take some of the lead on.
I'm sorry.
I think I could probably add to that. I think that's a conversation to be had with industry, and we would evaluate each of the NOIs on a case-by-case basis. But for future rulemaking, I don't know that based on what we read in the act and based on the concern from industry, that proposed regulations could be proposed by the industry, or there could be some conversations with the department.
Yeah, and I'll just add to the adding that we would not be just ignoring a portion of the Water Quality Act. That if a company came to us and said, we have confidential business information that we would like protected, and we would like to go through the notice of intent process, then we would be willing to work through that process with them. I'm not guaranteeing the company would be happy with our determination at the end of the process, but we would not just toss out 74-6-15 because it's an oil and gas company.
So what I'm hearing is that you're willing to talk to industry, but there's no standards by which industry would know that, yes, this information falls in the category of confidential, or no, it does not. Is that correct?
Yes.
Wouldn't this lack of protection for trade secrets and other proprietary information dissuade companies from investing in produced water treatment projects?
I believe I just said that that lack of existing confidential business information protection does exist. So I don't believe that we would be hampering projects with our actions at this time.
So you don't think it is discouraging people from participating?
I can't speak for them.
Well, there was a comment by NMOGA where they said something to that effect, that it would discourage people from participating. Did you see that comment?
I was in the room. I recall, I believe in the direct testimony from NMOGA that they stated that, yes.
So would you agree that that's a problem with the regulation as it stands right now?
No, I would not.
Why is that?
I did not write this rule for NMOGA. I'm sorry, we did not write this rule for NMOGA.
But you do want to encourage business innovation and technological advancement, right?
Yes.
And if the lack of protection of trade secrets inhibits that, you're not accomplishing your goals, are you?
As I stated, those protections exist.
I'm sorry, I didn't understand your answer.
The confidential business information protections exist in the Water Quality Act.
But there's no regulations about it.
Objection, asked and answered.
Yeah, you've established that, Ms. Taylor.
So moving to the specifics of the notice of intent provisions, I believe that Mr. Herman testified that NMED has no authority to require submission of all results of demonstration projects. Ms. Herman, that was in your direct on page 33, lines 21 and 22.
I believe that was in reference to our current authority without this regulation in place.
So are you basically asking for that authority here?
Yes.
So on May 6th, with its rebuttal testimony, the department added 2 new NOI requirements: the concentration of water contaminants in the untreated produced water and the quantity of produced water used in the demonstration project or industrial project, correct?
Yes.
So the department did not consider this information to be relevant or necessary for the rulemaking until May 6th, correct?
As I stated in my direct testimony, that was a mistake. I'm sorry, in my rebuttal. In my rebuttal testimony.
So I just want to think about an industrial user, putting aside the demonstration projects, but an industrial user who has a closed loop system with no discharge. Okay.
Yes.
And so my question is that if an industrial user wants to have a no discharge project to use treated produced water, he has to file a notice of intent, prove no discharge, right?
Yes.
And this industrial user or this company anticipates having an industrial process. He's going to set up a factory, and that factory is going to go for years. Okay. How can that industrial user predict the amount of water that he's going to use over the life of that project?
It's a fair question. And it's one we grapple with consistently with our existing notice of intent process. We accept estimates. We accept gallons per day, gallons per year, gallons per hour, total volumes. We will generally work with the person submitting the notice of intent to ensure that we have the information necessary to evaluate the project and its processes.
Very well. And then just one other issue, I think Ms. Murphy talked about a little bit, sort of a 2-step process for a notice of intent. In terms of the constituents within the untreated produced water, or I'm not sure who spoke. That, this was a long time ago when I took these notes. It was like 3 days ago. So I mean, so forgive me if my notes are wrong. But I think there was a question that if I want to have a demonstration project, not industrial, but demonstration, and I want to use 15 gallons of produced water, I have to tell you what I think is in that water, but in order to tell you, I have to already have an NOI. So can you explain sort of the 2-step process? Is it a preliminary look and then, and that's okay, and I'm not violating the NOI? Because is my question making sense there? So
Yes.
Yes. And I'll see if I can clarify, and Mr. Herman can add on if he feels it's needed. As far as, and Miss Murphy just alluded to it now, the treatment or the raw produced water quality, the treatment train, and then the effluent quality of that. And I believe it might have been me that testified on earlier this week on that. Essentially, there is produced water already being produced in the oil and gas field under OCD. That can be sampled, that can be characterized. That's what you would use to understand what the initial water quality is as required for the NOI.
I see.
So
So
it's not, yeah, go ahead.
So the operator would be testing the water under their authority under OCD.
Correct.
And then say, hey, this is what I have.
Correct.
Now I want to come to you, NMED,
To
and
take
get
it
an
off.
NOI.
Correct.
Okay, thank you. That's helpful. So I would like to talk now, just shifting gears, a little bit about the rule itself. When did you start drafting the rule?
I will take this question because I was the lead on the drafting. I came in April of 2023 to the Groundwater Quality Bureau, and I began looking at what was left as a real rough draft, and we worked from that. So from April 2023.
So the rule drafting, you don't know if it started in 2019 when the Produced Water Act?
I do not know.
So
And
I do know. So I've been on the project since early 2020, and the drafting of the very first version occurred almost immediately after I got on board. It went through 3 internal major versions before Ms. Fulham received that version in 2023.
So if I could just condense that to say the department in one way or another has been working on this for 4-ish years, right?
In some way, shape, or form, yes.
Okay. And I think this was asked before, but did members of this panel, were you the only drafters
yes,
for the rule that we have
from
today?
2020, April of 2023 on, we were the drafters. It did go through internal editing, but we were the drafters of that rule.
Thank you. Ms. Fulham, in your direct testimony, you said that a piecemeal rulemaking is required because a complete water reuse rule would take numerous years and science would become outdated before the WQCC could adopt a rule.
That is correct.
But don't other rulemakings, like the triennial review, take years?
Yes, and those are amendments. They're not a new rule.
And isn't it common for rules and regulations, including the surface water quality standards, to be frequently updated as scientific knowledge advances?
Yes.
And I understand that the triennial review is for surface waters roughly every 3 years, correct?
Under the federal regulations, the water quality standards are required to be reviewed every 3 years. And this is not in my testimony, but it is in my experience, both with tribal and with state water quality standard triennial reviews that I've held. They take usually about 5 or more years. So we review every 3 years.
But the point is the whole process takes a number of years.
It can.
And for groundwater, just to clarify, there is not a similar requirement to review them every period of time. Right?
There is not.
And so are those reviewed as things change, as science advances?
They are.
So I also think, Ms. Fulham, you have testified that a moratorium is not the directive or intent of the department's petition.
Correct.
But really, isn't that what this rule is with a complete ban on use of treated produced water? Isn't that a moratorium?
I would disagree that it's a complete ban on the use of produced water.
Explain that.
This rule has provisions for demonstration and industrial projects.
But if someone does a demonstration project and then wants to go forward and actually put that into use, they would have to wait for another rulemaking, correct?
Incorrect.
Incorrect?
Yes, a use is not necessarily descriptive of whether it's discharging or not discharging. There is a prohibition on discharges as proposed in this rule. There is not a ban on the use of produced water, however.
But and I presume you're alluding to industrial projects, is that correct?
Demonstration and industrial projects.
But if a industry member wants to use produced water, say to provide public water, as Mr. Hightower described yesterday, that particular use of tree to produce water would take a new rulemaking.
Correct.
And those rulemakings could take years.
It could. It depends on who the petitioner is.
What do you mean by that?
Under the Water Quality Act, any person can petition the commission for amendment to the rule.
So how could a petitioner shorten the time to get a rule? I don't understand.
If they have more resources and they have the data and they meet all the requirements of the acts for noticing and petitioning, it could take up to a certain amount of time. It's dependent on the evidence that's being presented, the extensiveness of the petition. Just like this rule is only 7 pages, but is taking a considerable amount of time, whereas a triennial review that we just did took 4.5 days worth of testimony for the review. So it's really dependent on the complexity of the petitioner's argument. And so if it's just adding or subtracting and it's straightforward, the petitioner could have a simple petition, but there's still the regulatory requirements which take time.
So, Mr. Herman, I think you have testified that neither the Water Quality Act nor the Produced Water Act includes any language authorizing the commission to adopt regulations that strictly prohibit the use of tree to produce water outside the oil and gas industry.
Thank you. I believe in my testimony that is within the context of the permitting regulations of 20.6.2 in the 3000s.
But doesn't this rule, initial rule, strictly prohibit the use of tree to produce water outside the oil and gas industry?
No, it does not.
Because of the reasons Ms. Fulham just explained?
Yes.
Because you can have an industrial project, a no discharge project, or a demonstration. So that change to the rule to go from getting a permit under standards to a ban in the March rule, the amendment in March, what I'm talking about, that shifted the rule to be a ban except for demonstration and industrial projects. Why did you make that change?
I can probably speak to that as I provided in one of my testimonies. It's either my rebuttal or my oral testimony. So as I've stated, all the information that the department has put out since 2019 was that we would have a restrictive rule that would allow for demonstration projects so that we could get more information to develop standards as we would think to be applicable or treatable. When we did the public comment, there was only demonstration projects, which were non-discharging. When we filed with the commission, there was a typographical error when we put in industrial. We inadvertently put in the word application, which would be contrary to the rest of that section in 400, because it implies a discharge that would require a discharge permit. When we found that essentially when we were drafting our written testimony to it and realized that's what had made it into the version that was petitioned before the commission. And that, I believe I state that believe it's in my rebuttal or my oral testimony.
So the permit provision that was in the rule before essentially was a mistake?
It was contrary to the language that was in section 400A, which said that there wouldn't be any allowable discharges. So it created an implementation issue. We can't say that there is a prohibition for discharges and then the next paragraph allow for a definition for a defined term that would require a discharge permit. So we needed to rectify that discrepancy.
And so the provision that you had in the earlier rule, and I'll be more specific in the December
Thank you.
rule, that talks about effluent and in effluent standards.
Which version of the rule are you referring to?
I believe the December version, NMED 71.
Okay, I believe that would be the public comment version.
Exhibit 71, I believe, is the petition for rulemaking and statement of reasons.
Yes, 71 was the version that was filed with the petition.
So thought that one had the discharge, or I'm sorry, effluent standards in it. Effluent quality, yes. It's at 20.6.8.400 D on NMED 001901, and it has effluent quality. So was that a mistake too?
As I stated in my rebuttal, in my oral testimony, I believe on Monday, I described the iterations of section 400D and how it started out from until such a time that there are effluent standards. Then it was amended to be simpler because there was duplication. And then it was the department who determined that this was adding confusion based on comments that we had received. And so now it's being removed entirely to not imply that there are any effluent quality that would be sufficient for use in applications.
And so let me make sure I understand. So earlier you said that you made the changes because you realized that you had a drafting error that didn't comport with the rest of the rule or the intent of the rule.
Are you speaking to the industrial applications?
Pardon me?
Are you speaking to the industrial
No,
applications?
I'm just talking about generally. I mean, earlier, in the earlier iterations of the rule, a permittee could get a permit to discharge treated produced water.
Objection, that misstates the witness's testimony.
Yeah. Ms. Fulham, can you address that in a way that's accurate?
The department did not have a draft rule at any time that allowed for a discharge permit or discharge of produced water.
Of treated produced, just treated produced water.
Treated or untreated.
Again, I'm looking at NMED Exhibit 71 under 400A2, where it says treated produced water discharged to surface water. And I'll paraphrase. It says, no person shall cause or allow treated produced water to discharge to surface water unless the discharger has obtained a permit approved by the department. It sounds like to me someone could get a discharge permit.
Correct, but I believe in the effluent quality, it states that there wouldn't be one. It says discharges of untreated produced water to surface or groundwaters of the state are prohibited.
Yes, ma'am, that does say for untreated, but I'm looking at A2 that says treated produced water. And it says you can discharge it if you get a permit.
Objection, that's not what it says.
Ms. Taylor, let's stick more closely to the language in the
Sure.
draft rule.
It says that no person shall cause or allow treated produced water to discharge to a surface water unless the discharger has obtained a discharge permit approved by the department.
Correct.
Okay, so the effluent quality in D on the next page that prohibits the discharge of untreated produced water is for untreated produced water, not treated produced water, correct?
That is what that says.
Okay, so at this point in this December rule, iteration of the rule, someone could have gotten a permit to discharge treated produced water.
There was language that implied that they could.
I think it more than implied it. I think it said that.
Objection. She's stating her opinion and not asking a question.
Right.
I'll move on. But I still, I think the basic question I have is, so that rule provides for a potential permit to discharge treated produced water, correct?
It implies that there would be the opportunity to submit an application for a plan that
Yes.
would be protective of groundwater.
And then in March, the rule was changed to be a ban of discharge of treated produced water, correct?
I will add that it aligned closer to the public draft version and then provided that prohibition.
What is the public draft version? I'm sorry.
I believe it was submitted as enemy.
Is that the public comment version?
Yes. NMED Exhibit 49.
And what I'm looking at is Exhibit 49, NMED page 001619, which basically is 400A C, I'm sorry, 400A3.
Okay.
And that says, no person shall cause or allow treated produced water to discharge so that it may move directly or indirectly into groundwater. I'm sorry, that's the wrong one. We'll just stick with surface water here. So A1. On that one does say that surface, that in accordance with this part, a produced water discharge of surface water is prohibited.
Right.
If I could just clarify, it was never, in my understanding, the department's intention to allow for discharge of treated or untreated produced water to any surface waters or groundwaters of the state.
In that particular public comment rule, let's call it Exhibit 49 for discharges to groundwater, which is A3, that does say, and I'll read it, that no person shall cause or allow treated produced water to discharge so that it may move directly or indirectly into groundwater unless the discharger has obtained a discharge permit approved by the department.
It continues on to say until such a time that water quality criteria based on scientifically defensible information about the composition, toxicity, fate, and transport of treated produced water is adopted by the Commission, the department shall not approve a discharge plan or a discharge plan modification that includes the discharge of treated produced water.
Correct, but that does imply, in your words, the ability to eventually get a permit, correct?
Until the Commission adopts criteria, there would be no discharge plan or discharge permit or
But
discharge plan modification that includes discharge.
But once the standards are set, a permit could be obtained. Correct?
Yes.
Okay.
We're coming close to the time when we need a break. Ms. Taylor, would you find a good time?
This is fine.
All right, let's take 10 minutes.
Your Honor, this is Mr. Maxwell. I'd like to know if there's I should be part of there.
Can you hear me?
I can hear you.
Okay, good. I have some of the parties here, not all of them. Okay. And they wanted to understand our basic strategy for going forward. And so the statement that I made before I turned on the microphone was that I would very much like to complete the cross-examination of the department panel before we do anything else other than public comment at 1, which we have to do. And I don't know how long that's going to take, but we need to finish it. After that is done, if Mr. Hightower is available, I'd like to go back to him. And then we'll go to Mr. DeSalen. Right. So anyway, juggling as hard as I can. Okay.
That's what we're asking to do.
Oh no, I thought, let's see. Right. Hold on. I have to go backwards. NMED, Amigos Bravos, NEE, WEG, Hightower, Center for Biological. Yeah, okay. Yeah.
So it might
Yeah,
be today or tomorrow morning.
it just depends on when we finish the department cross, and if when we reach out to him, he can actually leap on Zoom or sorry, WebEx.
And then the other question I have is, can for my examination of both who and Hightower, can I ask Ms. Jones to pull something up on the screen?
Yeah. So yeah, if it's in Dropbox, hold on one second. Pam, would you confirm that if it's in Dropbox, you're able to share screen? Okay, so probably the best thing to do is to warn her.
Well, what if I
Give her some
email
warning.
you?
You should have been sent a link.
Yeah.
Pam said she sent you.
I sent the email yesterday. I didn't get it.
And I checked both my email addresses. I got it.
Okay, good.
Okay, we'll make sure you have access to the Dropbox. Okay, so the best thing is to give her some warning. All right. Okay,
Outside of Dropbox.
great.